Jami-Lee Ross.
I'm
I'm going to hear David Clendon has 2 amendments. David Clendon.
Thank you, Mr. Chair. I'd just like to make some further comments about this bill and this part. As I said earlier, it's an okay bill. It could be a very good bill if it adopted the SOP in my name and inserted those words about repealing that section of the Crimes Act. I'd like to respond to 1 or 2 comments that Mr. Seymour made in his contribution. Firstly, he talked about, I think, what the Minister described earlier as unintentional criminalisation. He told us a cautionary tale of an innocent abroad who's coerced or intimidated or somehow persuaded to make a payment to a corrupt public official. And no doubt that goes on. I mean, we hear many stories of people stopped in vehicles and obliged to pay a road tax, which is actually going into somebody's pocket. Why this bill would not capture that sort of activity, abysmal though it may be, is contained in the section which I quoted earlier in the Crimes Act, which very clearly and specifically puts this matter about facilitation in the context of doing business. It talks about obtaining or retaining business or obtaining some improper advantage in the conduct of business. Mr. Seymour talked about operating in the real world, the practical matters that actually happen. The scenario he created is not one that would occur. There is no way, I believe, that in New Zealand we would prosecute a person who had been unknowingly, naively the victim of a corrupt official. If somebody, we would prosecute, I think we ought to prosecute people who go abroad and offer to make these payments in order to progress their business in a way that gives them some advantage. So I think that objection to the bill is not well founded because the context for the change is clearly spelt out in the context of doing business abroad. Mr. Seymour also quoted briefly from the Transparency International submission. He didn't quite get it right. I acknowledge he's a busy man. He must have read it in some haste. He told us that the UK prohibits facilitation payments. That's correct. He also told us that the UK government is not enforcing that prohibition, and that actually is not the case. To quote from the letter that he referenced, the submission from Transparency, the UK's Bribery Act 2010 prohibits facilitation payments, and these have always been illegal under previous UK corruption legislation, and goes on to say, although the UK has a low level of enforcement, we are advised that they will soon take action against an international organisation in the near future. I'm paraphrase slightly, but they talk about a low level of enforcement, which is a very different thing from not enforcing. It's entirely appropriate. I would not suggest for a minute that if we do pass this legislation and remove the exemption, that the next day we charge out mob-handed and start prosecuting people en masse. That's not the way laws happen. We like to think, perhaps in this chamber, that everybody's hanging on every word, that immediately we make law, that the public immediately know about it and understand it. I think the UK's approach, I'm inferring this, a low level of enforcement would be entirely appropriate initially because we are working against a very long period of improper action. It would take time for the business community to get their heads around the fact that this is no longer acceptable or legal. So I think the UK approach would be the appropriate one, a low-level enforcement, but then pick a good fight. Find somebody who's overtly and at some large scale breaking the law, breaking the prohibition and making these payments as a matter of course, and go after a big target and knock them down, and that would send a message to the people who might otherwise engage in this sort of activity, illegal as it is in the UK. So I do think that Mr. Seymour's objections are not well founded, and I do stand by the SOP. I think it would make this better law. Mr. Seymour also mentioned the Australian situation. Certainly they have been they are moving towards, I think, a more significant, a more closer to prohibition. The other organisations, the United States, have been complemented by the OECD because they are also moving towards a position of prohibition, of eliminating these facilitation payments. The OECD, APEC is another body that has spoken out against them, saying countries ought to move away. The opportunity here is for us to show something called leadership. let's for once be at the head of the pack. Let's lead the way and take a clear, principled, unequivocal position.
Jami-Lee